The Habeas Corpus Act 1679 is an act of the Parliament of England passed during the reign of King Charles II by what became known as the Habeas Corpus Parliament to define and strengthen the ancient prerogative writ of habeas corpus, a procedural device to force the courts to examine the lawfulness of a prisoner's detention in order to safeguard individual liberty and thus to prevent unlawful or arbitrary imprisonment. Earlier and subsequent history. The Act is often wrongly described as the origin of the writ of habeas corpus, but the writ of habeas corpus had existed in various forms in England for at least 5 centuries before and is thought to have originated in the 12th century Assize of Clarendon. It was guaranteed, but not created, by Magna Carta in 1215, whose Article 39 reads, "No freeman shall be taken or imprisoned or disseized or exiled or in any way destroyed, nor will we go upon him nor will we send upon him except upon the lawful judgment of his peers of the law of the land." The Act of 1679 followed an earlier Habeas Corpus Act of 1640, which established that the command of the King of the Privy Council was no answer to a petition of habeas corpus. Further Habeas Corpus Acts were passed by the British Parliament in 1803, 1804, 1816 and 1862. But it is the Act of 1679 which is remembered as one of the most important statutes in English constitutional history. Though amended, it remains on the statute book to this day. Content: in criminal matters other than treason and felonies, the Act gave prisoners or third parties acting on their behalf the right to challenge the detention by demanding from the Lord Chancellor, Justices of the King's Bench, and the Barons of the Exchequer of the jurisdiction a judicial review of their imprisonment. The Act laid out certain temporal and geographical conditions under which prisoners had to be brought before the courts. Jailers were forbidden to move prisoners from one prison to another or out of the country to evade the writ. In case of disobedience, jailers would be punished with severe fines which had to be paid to the prisoner. Parliamentary history. The Act came about because the Earl of Shaftesbury encouraged his friends in the Commons to introduce the bill where it passed and was then sent up to the House of Lords. Shaftesbury was the leading exclusionist, those who wanted to exclude Charles II's brother James, Duke of York, from the succession, and a bill was a part of that struggle as they believed James would rule arbitrarily. The Lords decided to add many wrecking amendments to the bill in an attempt to kill it. The Commons had no choice but to pass the bill with the Lords' amendments because they learned that the King would soon end the current parliamentary session. The bill went back and forth between the two houses, and then the Lords voted on whether to set up a conference on the bill. If this motion was defeated, the bill would stay in the Commons and therefore have no chance of being passed. Each side, those voting for and against, appointed a teller who stood on each side of the door through which those Lords who had voted aye re-entered the House. One teller would count them aloud whilst the other teller listened and kept watch in order to know if the other teller was telling the truth. Shaftesbury's faction had voted for the motion, so they went out and re-entered the House. Gilbert Burnet, one of Shaftesbury's friends, recorded what then happened. Lord Grey and Lord Norris were named to be the tellers. Lord Norris, being a man subject to vapours, was not at all times attentive to what he was doing. So, a very fat lord coming in, Lord Grey counted him as 10, as a jest at first, but seeing Lord Norris had not observed it, he went on with this misreckoning of 10. So it was reported that they that were for the bill were in the majority, though indeed it went for the other side, and by this means the bill passed. The clerk recorded in the minutes of the Lords that the ayes had 57 and the nays had 55, a total of 112. But the same minutes also state that only 107 Lords had attended that sitting. The King arrived shortly thereafter and gave royal assent before proroguing Parliament. The Act is now stored in the Parliamentary Archives.